Today, I would like to talk about why psychiatrists and psychologists should testify on the courtroom in behalf of non-guilty by reason of insanity plea. First, I would like to talk about forensic psychology, which is used in the courtroom. It's a clinical psychology specialty which intertwines the law with two types of professional services. First, it's going to do a psychological evaluation and assessment to assist the defense or the prosecution in criminal cases as well as civil court proceedings, and the rehabilitation of criminals once they're inside the prison system. Now, when a person is charged with a misdemeanor or a felony, their mental state or mental illness may be an issue to consider before conviction or before sentencing. The attorney representing the accused person may request a psychological evaluation, or the psych evaluation could be court-ordered. The state carries the burden of providing that, beyond the reasonable doubt, that the defendant was formed the requisite min rea to commit the crime. The min rea is Latin for guilty mind, so they were in their guilty mind. They knew what was going on. A reasonable doubt is a doubt based on reason and common sense after careful and impartial consideration of all evidence in the case. It's a kind of doubt that would make any reasonable person hesitate to act in the most important of his or her own affairs. Now, in a criminal law concept, which focuses on mental state of the accused, did the person know that their act or admission was illegal or prohibited? And that's where those psychological psychiatrist exams come in. When the court appoints one of those people as an expert witness, which they can do with a psychologist or psychiatrist, they examine the defendant. A determination is made whether there is substantial evidence at the time if a patient suffers a mental disorder. And just to let everybody know, emotions such as fear, jealousy, anger, hatred are not considered a mental disorder. They have to have a true mental disorder such as bipolarism, schizophrenia. I wouldn't say any of those like Downs or anything. That's not really one, but it has to be one of those that really inhibits the way your brain processes things. They have to determine and they need to consider the psychological influences at the time, at the scene of the alleged crime. Now, that could be social situations, injury, physical illness, medical, neurological diseases that affect your brain, such as bipolarism or schizophrenia, adverse environmental conditions, etc., such as were they on their medication, were they off their medication. Depending on the outcome of the examination, a psychologist or psychiatrist may testify in court how the impaired mental abilities actually cause a malformation, so cause issues with the mental element of the crime. So that means that they need to determine why this was caused. Was it something like extreme social pressure to fit in and they snapped, or if they were off their medication and they needed it to help balance out the chemicals in their brain. If they couldn't obtain those medications, if they were forced to do this, if they were told that they had to kill somebody, or they were having voices in their head that was telling them to kill someone. And so it says an expert opinion is rendered regarding whether the mental element probably failed to be formed. So that means, is there something that's blocking you from forming those opinions of, hey, is this right or is this wrong? Am I supposed to really be doing this? Is there really something telling me to kill this person, or is there's something that's going on psychologically? The expert does not have to be certain that the defendant's disorder caused him or her to be unable to form the intent or knowledge, but the expert must have some belief in the probability or possibility that it did. Experts need to testify with reasonable medical and psychological certainty, and that's why they are able to be expert witnesses and they are able to testify, is because they are considered expert witnesses because they have a psychology degree. And so that gives them more of a leg to stand on than just you or I, who are common people that have no education in this and have no understanding of how humans' minds truly work. In addition to a plea of not guilty, if the defendant has entered a plea of insanity existing at the time of the act charge, insanity at the time of the commission of the act charge is a defense. So this is the judge's instructions to the jury, and for a defendant to not be found guilty by reason of insanity, you must find, as a judge, the result of the mental disease or defect. The defendant's mind was affected to such an extent that the defendant was unable to perceive the nature and quality of the acts which with the defendant is charged, or was able to tell right from wrong. Again, you really need a psychologist or a psychiatrist to be able to do this. And if their court is ordering for one of these people to go in and interview and do an evaluation of this criminal, they should be able to have the right to provide their testimony, to provide the evidence that they found. There's also just three different main areas related to mental health: so the diminished capacity, competency, and mitigating circumstances. And again, who can determine that? None other than a psychologist or a psychiatrist. A judge shouldn't really be allowed to handle that. A judge might see criminal court cases every single day. They might see civil court cases every single day, but that doesn't qualify them to be able to determine if somebody's guilty of insanity or if they're not. They should not have that right. A jury shouldn't have that right. It should be a psychologist or a psychiatrist that performs a mental evaluation and gives this person a right, fair trial, because a lot of times people let their humanity get the best of them and believe that ethically these people are wrong and they should be punished severely for what they do, whether this person has issues or not, whether they're incapacitated or not. A psychologist or psychiatrist who is asked to prepare a forensic psych evaluation to examine and evaluate a patient in anticipation of persecution or litigation may be recognized by the court to serve as an expert witness. An expert witness, by virtue of education, profession, and experience, is considered to have special knowledge of the subject beyond that of the average person, sufficient that others may be legally and officially rely on its opinion. So that being said, again, they should be able to testify because they are acknowledged as having expert opinions versus somebody in the jury. When you have these forensic psychologists come in and they examine the crime scenes and they tell you this person's guilty, but they can also look and say, this person had some other issues going on. We can look back over their history, if they've had any other run-ins with the law, and see if they should be sentenced as a regular criminal proceeding or if they should be proceeded with the insanity plea. And that's why I feel that we should be able to have psychologists in the courtroom, and they should be able to testify as, if not mandatory testification, is that a word, to help out our court rulings in order to make things more fair and more efficient when someone steps before the judge for any type of crime that they commit. As well as, a lot of times you have to look at these mass murders or shootings or bombings. Would a court psychologist work? Yes, they would. They would be able to tell you if this person's just mad and angry because they didn't get their way, or if they truly have something wrong with them before the public is able to crucify them. Thank you.